Welcome to our Arizona Revised Statutes video library. I'm Shawnna Riggers, Managing Attorney at Arizona Family Law Attorneys. My goal is to take this somewhat dry information, make it a little bit more entertaining, and also provide you with information regarding the laws that are applicable to dissolution, parenting time, custody, child support cases here in Arizona. This is being filmed in 2023, so it's important that if you're seeing that afterwards, that you double check the statute to make sure that it is the most current version. And if you have any questions regarding any of the material, as always, please feel free to reach out to us here at Arizona Family Law Attorneys, where we provide peace of mind as there is no substitute. I'm going to read the second half of 25-320, and then I'll discuss it at the end. Be sure to watch part 1 for this statute too, because I gave a lot of information. If you have questions, reach out to me directly. Subsection G. If a personal check for support payments and handling fees is rightfully dishonored by the payor bank or other drawee, the person obligated to pay support shall make any subsequent support payments and handling fees only by cash, money order, cashier's check, traveler's check, or certified check. If a person required to pay support other than by personal check demonstrates full and timely payment for 24 months, that person may pay support by personal check if these payments are for the full amount, are timely tendered, and are not rightfully dishonored by the payor bank or other drawee. H. Subsection G of this section does not apply to payments made by means of an assignment order. I. If, after reasonable efforts to locate the obligee, the clerk or support payment clearinghouse is unable to deliver payments for the period prescribed in 25-503 due to the failure of the person to whom the support has been ordered to be paid to notify the clerk or support payment clearinghouse of a change in address, the clerk or support payment clearinghouse shall not deliver further payments and shall return the payments to the obligor consistent with the requirements of 25-503. J. An order for child support shall assign responsibility for providing medical insurance for the child who is the subject of the support order to one of the parents and shall assign responsibility for the payment of any medical costs of the child that are not covered by insurance according to the child support guidelines. Each parent shall provide information to the court regarding availability of medical insurance for the child that is accessible and available at a reasonable cost. In Title 4D cases, the parent responsible pursuant to court order for providing medical insurance for the child shall notify the Child Support Enforcement Agency in the Department of Economic Security if medical insurance has been obtained or if the child is no longer covered under an insurance plan. K. If the court finds that neither parent has the ability to obtain medical insurance for the child that is accessible and available at the court at a reasonable cost, the court shall, 1, in a 4D case, in accordance with established 4D criteria, establish a monthly reasonable cash medical support order to be paid by the obligor. If medical assistance is being provided to a child under Title 19 of the Social Security Act, cash medical support is assigned to the state pursuant to Section 46-407. On verification that the obligor has obtained private insurance, the cash medical support order terminates by operation of law on the first day of the month after the policy's effective date or on the date the court or the department in a Title 4D case is notified that insurance has been obtained, whichever is later. If the private insurance terminates, the cash medical support order automatically resumes by operation of law on the first day of the month following the termination date of the policy. 2. Order one parent to provide medical insurance when it becomes accessible and available at a reasonable cost. 3. Order that medical costs in excess of the cash medical support amount shall be paid by each parent according to the percentage assigned for payment of uninsured costs. L. In a Title 4D case, if the court orders the non-custodial parent to obtain medical insurance, the court shall also set an alternative cash medical support order to be paid by that parent if the child is not covered under an insurance plan within 90 days after entry of the order, or if the child is no longer covered by insurance. The court shall not order the custodial parent to pay cash medical support. M. In Title 4D cases, the Superior Court shall accept for filing any documents that are received through electronic transmission if the electronically reproduced document states that the copy used for the electronic transmission was certified before it was electronically transmitted. N. The court shall presume, in the absence of contrary testimony, that a parent is capable of full-time employment, at least at the applicable state or federal adult minimum wage, whichever is higher. This presumably does not apply to non-custodial parents who are under 18 years of age and who are attending high school. An order for support shall provide for an assignment pursuant to sections 25,504 and 25,323. P. Each licensing board or agency that issues professional, recreational, or occupational licenses or certificates shall record on the application the Social Security number of the applicant and shall enter this information in its database in order to aid the Department of Economic Security in locating parents or their assets to enforce child support orders. This subsection does not apply to a license that is issued pursuant to Title 17 and that is not issued by an automated drawing system. If a licensing board or agency allows an applicant to use a number other than a Social Security number on the face of the license or certificate, while the licensing board or agency keeps the Social Security number on file, the licensing board or agency shall advise an applicant of this fact. Q. The factors prescribed pursuant to subsection D of this section are stated for direction to the Supreme Court. Except pursuant to subsection E of this section and sections 501 and 809, the Superior Court shall not consider the factors when making child support orders independent of the child support guidelines. R. For the purposes of this section, 1. Accessible means that insurance is available in the geographic region where the child resides. 2. Child support guidelines means the child support guidelines that are adopted by the state Supreme Court pursuant to 42 United States Codes sections 651 through 669B. 3. Date of separation means the date the married parents ceased to cohabitate. 4. Reasonable cost means an amount that does not exceed the higher of 5% of the gross income of the obligated parent or an income-based numeric standard that is prescribed in the child support guidelines. 5. Support has the same meaning as prescribed in section 25,500. 6. Support payments means the amount of money ordered by the court to be paid for the support of the minor children. I think the most important takeaways from this section are, first and foremost, most child support orders are actually paid by order of assignment, meaning that the parent's obligation to pay child support is actually taken directly from their paycheck, never goes into their pocket, and is immediately sent over to the child support clearinghouse. I personally think that this is the best way, as it's automatic and there's much less enforcement actions that happen when child support is paid automatically. The other important piece of this is insurance for the minor child. So if one parent or both parents has the ability to pay for insurance through their employer, they are allowed to do that. Children may be able to be eligible for access, but this statute basically implies that it is important for children to have health insurance but it is not mandatory. If a parent does not have the ability to access health insurance, the court cannot order them to go find a policy. And the last thing that I think is important is the child support guidelines actually state the percentages that each parent should pay for unreimbursed medical expenses. Those are typically derived from the party's income. They take both parties' income, put them together, and then take out the fraction. So let's say one parent makes 75%, the other's 25%. That percentage would then be applied towards unreimbursed medical expenses, meaning anything outside the copay that would need to be paid would be 75% by parent A and 25% by parent B.